Iraq contribution of the UNCITRAL Committee in the context of international trade. International trade exchange means achieving faster growth and higher standard of living and providing new opportunities through trade in general and international trade in particular. In order to increase these opportunities on a global scale, there must be a legal framework and international committee working to lay down modern, fair and harmonious foundation, laws and rules regarding commercial transaction. Specialized entities vary at the international levels to show us special and essential party on the commercial level that has had and still has an important and essential role in the various fields of international trade, and this is the United Nations Commission on International Trade Law, a subsidiary entity of the United Nations General Assembly responsible for assisting in facilitating international trade and investment. Its mission is to modernize and harmonize the rules relating to international business and is referred to by the acronym UNCITRAL, United Nations Commission on International Trade Law. The UNCITRAL Commission has played a large and multiple role in the field of international trade in general and in the field of commercial arbitration, in particular through its arbitration legal preparation, the most important of which were the New York Convention on the Recognition and Enforcement of Foreign Arbitration Provision of 1958, as well as the UNCITRAL International Commercial Arbitration Act of 1976 as amended in 2010, Model Law on Commercial Arbitration 1985 revised 2006. UNCITRAL text commenced, drafted and adopted by the United Nations Commission on International Trade Law. UNCITRAL carries out the mandate entrusted to it by General Assembly Resolution 2205, paragraph 8. Coordinating to the work of organizations active in the field of international trade law and encouraging cooperation between them. Promote wider participation in existing international agreements and wider acceptance of existing model and uniform law. Preparing international agreement, model law and new unified laws or promoting their adoption and promoting the codification of term, provision, norms and practices related to international trade and to broadening the scope of their acceptance in cooperation with organizations working in this field when necessary. Promoting ways and means that ensure the interpretation and uniform application of international agreement and uniform laws in the field of international trade law. Collecting and disseminating information on national legislation and recent legal development, including case law in the field of international trade law. Establishing and maintaining close cooperation with the United Nations Conference on Trade and Development. Maintaining connection with the other United Nations bodies and specialized agencies concerned with international trade. Take any other measures that it may deem useful to perform its function. The United Nations Commission on International Trade Law as an entity defending the interests of international trade. UNCITRAL isn't part of the World Trade Organization as it is a subsidiary body of the United Nations General Assembly. The UNCITRAL Secretariat is the International Trade Law Division of the Office of Legal Affairs of the United Nations Secretariat. The World Trade Organization, WTO, is an intergovernmental organization independent of the United Nations. The issues dealt with the WTO and UNCITRAL are different. The organization deals with trade policy issues such as trade liberalization, the elimination of trade barriers, unfair trade practices, or similar issues usually relating to common law, while UNCITRAL deals with the laws applicable to private parties in international transactions. Hence, UNCITRAL doesn't address interstate issues such as anti-dumping, countervailing duties, or import quotas. The UNCITRAL Commission dealt with many topics and issued special model legislation for them. Among the topics and works are: first, the international sale of goods and related transactions. The United Nations Convention on the Limitation Period in the International Sale of Goods, New York, 1974, which established uniform rules for regulating the time period during which legal procedures arising from contract for international sale should begin. The convention was amended by a protocol adopted in 1980 and the entry into force of the original and amended convention on 1/8/1988. The United Nations Convention on Contract for the International Sale of Goods, Vienna, 1980, which established a comprehensive code of legal rules regulating the formulation of contract for international sale and the obligation of the seller and buyer, which entered into force on 1/1/1988. The UNCITRAL Legal Guide on International Equivalent Trade Deals, which was adopted in 1992. The guide seeks to assist parties negotiating international trade deals and identifies the legal issues involved in those deals and discusses their possible contractual solution. Second, international transport of goods. The United Nations Convention on the Maritime Transport of Goods, Hamburg Rules, 1978, which established a unified legal system regulating the right and obligation of shippers, carriers, and consignees under the contract of carriage of goods by sea, and its entry into force on 1/11/1992. The United Nations Convention on the Responsibility of Terminal Operators in International Trade, which established unified legal rules regulating the liability of terminal operators for the loss or damage of goods that occur in transportation and for the premised delay in delivery. The agreement was ratified on 19/4/1991. Third, international commercial arbitration and conciliation. The UNCITRAL arbitration rules, which contain a comprehensive set of procedural rules that the parties may agree upon, are widely used in individual structured arbitration and were adopted in 1976. Recommendation under the UNCITRAL arbitration rules, 1982. The UNCITRAL Conciliation Rules, 1980. The UNCITRAL Model Law on International Commercial Arbitration, 1985, which assists countries in reforming and updating their laws relating to arbitration procedures, and many countries have adopted it as the arbitration law in their own countries. UNCITRAL Notes on the Organization of Arbitral Proceeding, 1996, to assist arbitration practitioners by providing an annotated list of issues on which an arbitral tribunal may wish to formulate decision. Convention on the Recognition and Enforcement of Foreign Arbitral Award. Fourth, Procurement and Infrastructure Development. The UNCITRAL Model Law on the Procurement of Goods, Construction and Services, 1994, assists states in reforming and modernizing their procurement laws and includes procedures to achieve the objective of transparent competition and fairness. UNCITRAL Guide on Privately Financed Infrastructure Project 2001 to existing establish a legal framework for private sector investment in infrastructure and encourage its participation. Thank you.